My name is Mark Fessler. I'm a housing attorney with South Carolina Legal Services, and I want to talk to you today about some basic procedures that you're going to encounter if you get sued for foreclosure in South Carolina. Now, you may have heard your mortgage company tell you, well, you're in foreclosure, or you're with our foreclosure department. Under the law, you're not actually in foreclosure until you have been served with a summons and complaint for foreclosure. Included with the summons and complaint for foreclosure, you also have to be served what's called a notice of foreclosure intervention. And that's what I want to talk to you about today, is what is foreclosure intervention and what rights do you have under that process? Foreclosure intervention is a process that was established by South Carolina Supreme Court back in 2011. It gives the mortgage company and the borrower time to try to work out a arrangement, also called a loss mitigation arrangement, prior to the foreclosure moving forward. But there are some important deadlines and steps that you have to meet if you want to go through foreclosure intervention. First, you should know that when you get the summons and complaint for foreclosure, there should be a notice of foreclosure intervention in that packet of information. You need to read that notice as it will give you some instructions about how to request foreclosure intervention. The basic idea is that you need to respond, preferably in writing, and let the mortgage company's attorney know that you want to participate in foreclosure intervention. So something as simple as a letter, or perhaps even an email, or perhaps even a phone call could do the trick. The idea, though, is you need to use the phrase foreclosure intervention, and you need to let the mortgage company's attorney know that you want to participate in that program. When you respond to the notice of foreclosure intervention, you also want to follow up with the mortgage company's attorney in, say, 1 or 2 days after you send the request to make sure they got it. You only have 30 days to decide whether you want to participate in foreclosure intervention or not. That's 30 days from the date that you get served with the summons and complaint. If you don't make any election to participate in foreclosure intervention, then the mortgage company's attorney can certify to the court that you failed, refused, or voluntarily elected not to participate, and the foreclosure can move forward. If you choose to participate in foreclosure intervention, then the next step is you need to submit a loss mitigation application to the mortgage company. Now, you can submit this directly to the mortgage company or through the mortgage company's attorneys, but the best practice is to send your application to both parties. Now, how do you know what to put in your loan modification or loss mitigation application? This information has to come from the mortgage company. Although most mortgage companies have some similar requirements, such as getting copies of your bank statements, pay stubs, perhaps your tax returns. Some mortgage companies have different requirements than others, so you need to contact your mortgage company to find out exactly what documents they are going to require to review your loss mitigation application. Also, you should keep in mind that there are deadlines to these loss mitigation applications. Usually you have about 30 days to submit the initial application after you request foreclosure intervention. You should also know that most of the time you will be asked for additional documents, and those documents have to be sent back to the mortgage company by a particular deadline. So be very sure that you know the deadline by which you're expected to return any additional information throughout the entire process. Another point you should be aware of is that you want to be able to keep proof, or you want to be able to prove what you sent, when you sent it, who you sent it to, and who received it. A lot of mortgage companies have online internet portals where you can upload and send documents, or they have email addresses where you can attach files and email documents to the mortgage company, or you can fax documents to most mortgage companies. Email is preferable. Fax is probably a second best option. You can mail documents, but if you mail documents in, you want to do it certified mail or FedEx or UPS, or some way where you can track the delivery date for those documents. And you also want to make sure that you keep documents of anything that you mail to the mortgage company, so that if the question comes up as to whether you sent in everything that was asked for, you have a full copy of what you sent. Once you have submitted a full and complete loss mitigation application, you should get a letter from the mortgage company telling you that the application is complete. The mortgage company then has roughly 30 days to review that application and tell you whether you qualify for any of the loss mitigation programs that that mortgage company offers. Now, loss mitigation programs include a variety of things such as loan modification, which is of course the most popular, but it also includes things like a repayment agreement, a reinstatement agreement, a short sale, or a mortgage forbearance. If, after you have submitted a complete loss mitigation application, you are still denied for any modification or mitigation relief, then you're going to get a notice from the mortgage company's attorney saying that you've been reviewed for all the loss mitigation options available and you don't qualify for any of them. That notice also should tell you that you have 30 days to formally answer the complaint. Now, answering the complaint goes beyond the scope of this talk, and so I encourage you, if you need to answer a foreclosure lawsuit, to consult with an attorney to see what kind of defenses or possibly counterclaims you may have to the suit. Also, before the foreclosure can move forward, the mortgage company's attorney has to certify a number of things to the court. They have to certify that you have been given notice of your right to foreclosure intervention, that you have submitted a modification or loss mitigation application, that information has been fully and completely reviewed by the mortgage company, and that you do not qualify for any relief options. If they don't send that certification to the court, then the lawsuit cannot move forward. As I said earlier, if you fail to respond to the notice of foreclosure intervention, if you fail to say that you want to participate, then all the mortgage company has to do is certify that you never responded, that you failed to participate, and then the mortgage foreclosure can move forward. And that really sums up what foreclosure intervention is. It's just a time period that you can elect to participate in within 30 days after you get served with the initial summons and complaint. And it will pause the foreclosure and give you time to try to work something out with your mortgage company. Keep in mind, it only applies to homeowners who occupy the property that they're living in. And there are also some other complexities that can come up that we don't have time to really get into, but that I would advise you to consult with an attorney about if you have questions or run into problems, or if you run into problems trying to get through the foreclosure intervention process. Examples of complexities are where, for example, you have inherited a piece of property. That can create problems for you because you may have to assume the loan before you can engage in loss mitigation. Other examples are situations where you have gotten the property through a divorce, and if the divorce is not finalized, that can create problems for loss mitigation efforts. Another example is where you're relying on somebody else's income to apply for a loan modification. Or if, for example, if you're self-employed and you don't have a easy way to document the kind of income you receive, that can also add complexity. So in situations that go beyond the basic process that we've just talked about, that are more complicated, it's probably a good idea to try to consult with an attorney to see what you need to do to make sure you're as successful as you can be.